Today we're with David Shapiro. David Shapiro is a criminal defense attorney in Southern California, specifically in San Diego, California. Today he's agreed to answer some online questions related to criminal law. If you actually have some additional questions, you can post them down to the YouTube comments below, and he's agreed to answer those directly for you. Also, obviously, if you have some more serious pressing concerns, just give him a call, or you can visit his website at the information posted below at the YouTube video. With that said, we want to get into the first question that was posted today. Is California tougher on DUI than other states?
That's a good question. Depends. It depends on what state we're talking about. Obviously, there's other states that can, I've seen, be more harsh on first-time DUIs. There's other states that have not. I remember where I'm from originally in New York, and I did a lot of work when I was in school working with a defense firm that had the contract for indigent defense in New York. And I remember first-time DUIs basically getting reduced to infractions unless there were, some complicated facts or bad injuries or really high blood alcohol level or priors. California, you're not getting an infraction on 99.5 out of 100 DUI, misdemeanor DUI arrest. However, there's other states that first-time DUIs require 10 days jail, 5 days jail, 20 days jail. California's not one of those states. So, my experience has been overall, obviously my practice has been in California, specifically Southern California and San Diego. I think within California you see a difference within the counties of which counties may be tougher on even first-time DUIs than others. My experience has been that once you get to a third-time DUI within 10 years in California, it's 120 days to a year in jail. So that's a pretty harsh sentence, comparatively speaking, to other states. However, I just heard something or read something actually earlier this week, I think on Google Plus, someone posted an article about Colorado, this bill that they were trying to pass to make first-time DUIs without an injury, obviously without any priors, be a felony. If that's the case, I think Colorado would take the cake as the toughest state on DUIs, but we'll see. I don't think that one's going to pass.
Okay. Let's see. Can you tell me ahead of time what should happen to me at the end of my case?
Well, hopefully you're happy with the attorney you hired. What could happen at the end of your case? I mean, I could, pretty much give you a couple of realistic options. I definitely do not give percentages. No attorney should. I think we've talked about that in some other video blogs we've done. Bottom line is when I tell people, when I meet with them, I tell them, hey, this is what the law says could happen to you. This, I think, is more realistically what the realistic options are of the case resolving one way or the other. And we pretty much narrow the scope of realistic options throughout the case, starting very wide array, a wide net at the beginning. And then as we learn more about the evidence, I learn more about my client, we have more interaction with the court and the prosecutors, we sort of narrow it down. And then a lot of times what I will do is put a client at ease, hopefully, at least that's my intent, by saying, hey, worst case realistically, this is what your sentence will be, this is what you will have at the end of the case, and then we can work off of that. So if they can live with the worst case, then they put some at ease, and they know, hey, it's going to be okay, I can get through this, obviously with the help of the attorney I hire. But I could predict, depending on most cases, I could give you at least a framework of realistically what's the worst that could happen. And then obviously we work off that and trying to get, as is the goal with any case we handle, to get the best outcome possible, which is where you walk out of this without a criminal conviction.
Okay. All right. Next question we have is, do any criminal attorneys work on a contingency basis?
Some might. I don't. And there's a reason why. Criminal cases is difficult to quantify, so to speak. What is a win? If I do a contingency basis, and just so we're clear, a contingency basis is, I get paid whatever, a third of whatever the proceeds are of the win. So say it's a civil case and someone gets a $100,000 verdict. If I'm working on a 30% contingency, I'm getting $30,000, and that covers my fees. If we lose the case, I get nothing. Well, civil attorneys sometimes have an opportunity to pick and choose, obviously, what cases they take, and they usually don't take cases they don't think they can win. Well, with criminal law, specifically criminal defense, it's a little more difficult. It's you could be facing, or your client could be facing 7 charges, and you could go to trial with the only realistic goal of beating the most serious 2 or 3. And you could get convicted of 5 of those 7 counts, but you and your client could not be happier at the end of the case. Now, is that a win? Yeah, it is. But the client was still convicted of 4 or 5 counts, whatever it is. So, I think it's foolish for criminal attorneys to take cases on a contingency basis. There's too many variables, and a lot of times we cannot control, as a criminal defense attorney, the weight of the evidence against our client. What we can do is mitigate it and deal with it as best we can and try and keep certain pieces of evidence out. But I do not, at least I have not, I don't want to say will not ever, but I have not ever, going on now 7+ years in practice, approaching 5 years in my own business at the law office of David Shapiro. I've never taken a contingency case, and I'm not sure I ever will.
Okay, well that makes total sense now. And then the last question we had is, if I'm convicted of a DUI, will I lose my license?
Yes, and you may also have your driving privileges suspended in California, even if you don't get convicted of a DUI, if you were to lose the administrative hearing. First time DUI, you have no record, you get arrested. You will be given, for argument's sake, let's assume you're a California resident with a California driver's license. Your physical license will be taken and you will be given a pink piece of paper. On that pink piece of paper, that will be your temporary license for the next 30 days. You will have 10 calendar days from your arrest to set up your DMV hearing. So what that means is if you get arrested on February 1st, you will have until February 11th to call DMV and set up your DMV administrative per se hearing. The hearing is not within 10 calendar days, but you have 10 calendar days to set it up. Usually the hearing will be a month or month and a half out. That preserves your driving privileges pending the court case and pending that administrative per se hearing. It's a hearing at DMV, totally separate. You could win that hearing and have the worst criminal court case in the world for a DUI. You could lose that hearing and have the best case in the world. So going back to how I started it, you could lose that administrative per se hearing on a first-time DUI and your license would be suspended for a period of 4 months. You could win that hearing and then go to court, and then if you're convicted of a DUI, your license will be suspended for a period of 6 months for a first-time DUI with no priors. Obviously, if your attorney is successful in negotiating a lesser related offense or to get the DUI dismissed and plead to something lower than that, a wet reckless, a dry reckless, what have you, that would not have an effect on your license in that you were convicted of that offense. What I mean by that is a lot of times attorneys don't advise their clients that some of these lesser included offenses of DUIs, although they may not trigger an automatic suspension under certain vehicle code provisions, will give points on or will lead to that person, their client, getting points on their driving record. You get in problems in California if you have 4 points in a year, 6 points in 2 years, or 8 points in 3 years on your DMV record. A lot of times people think, oh wow, I beat this DUI, I'm going to plead to this lesser related offense, my license is good, and their attorney didn't advise them that, well, it's going to be 2 points on your record, and if you have a bad driving record, you might lose your license even if you beat the DUI, and even if you beat the administrative per se hearing. But definitely, if you're convicted of a DUI, even a first time, you're looking at a 6-month suspension. Obviously, you could get restriction after no more than 30 days of a hard suspension. And obviously, if you have prior DUIs within that 10-year window of priorability, the penalties go up. 1 year ultimately can lead to license revocation and an ultimate ban on your driving privilege.
Okay. Well, David, appreciate the answers. Again, if you're watching this and looking for an attorney, feel free to give David a call. You can also post your questions below in the YouTube comments. And David, I want to thank you again for your time.
My pleasure. Thank you.